One common myth with wills and probate is that if someone dies without a will, that the state will get everything. When in reality, when someone dies without a will, that's known as an intestate estate. And under an intestate estate, your assets will pass according to statute, which is known as intestate succession. And under statute, there are many people in line before the state would get anything from your estate. So there is your spouse, your descendants, including your children and grandchildren, your parents, your siblings. They all come before the state would get anything under an intestate estate. Another common myth is that it takes years to probate an estate. In reality, at minimum, an estate must stay open for at least 9 months to allow creditors the opportunity to come forward. Other than that initial 9 months, once that 9-month period has passed, the executor or administrator of the estate can move forward with wrapping up the estate, and otherwise known as settling the estate and closing the estate out. It's really only in those estates that involve disputes among family members that are brought to the court that can extend the probate of an estate, or high net worth estates that can take longer to marshal the assets and pay taxes and address any income that may be received by the estate, that really take longer than that expected 9-month to a year period. Generally, the costs associated with probating an estate are relatively nominal compared to the estate's total assets. Those fees are administrative fees typically associated with distributing the assets, paying any estate taxes. The executor and or administrator may be entitled to compensation in their role in administering the estate, as well as any attorney's fees that may be associated with representing the estate. Another common myth for wills and probate is that you have to leave anything to your spouse. You do have the ability to choose to not leave anything to your spouse. However, you should be aware that if your spouse is not on the same page, your spouse does have rights under the law to a certain percentage of your estate. So if that is something you would like to do, it is important that you speak to an attorney about what you would like to do, as well as your spouse, to ensure that you are on the same page as far as what you may or may not want to leave to them after your death. So another common myth for wills and probate is that the oldest child is entitled to be the executor of their parents' estate. The parents have the right to select if in drafting their will, they have the right to appoint any child as their executor or a non-child as their executor, anybody that they choose. The decision about who should serve that role is not at all impacted by where in line your children may fall, whether it be the oldest, the youngest, or the middle child, or again, whether it be somebody that's not even related to you.